Hello everyone, and welcome back to another episode of the Darrell Brooks saga. No, you're not seeing double. I just wanted to let you guys know that we actually made the first upgrade to the channel. See the one, well, I'm pointing to this camera is my old webcam, so we now have an actual camera. You can now see the actual color of my face. You see this, I don't know, the other one was weird, but thank you guys. Thank you guys for your support. I'm gonna try to continue to do more of these upgrades to the channel. So thank you guys for that. Especially, let me just get rid of this. There you go. Especially to our members. Where was their members? There you go. There you go. We have doubled the members now. We got two more. M-Bond and Sea Sky. They're backed. They are officially members of the channel. So thank you so much for that. All right, with that out of the way, let's go into the video because this is a good one. This one is when Mr. Darrell Brooks explodes because of the video that he asked to be played, basically. So let's get right into it.
Attorney Opper, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take that under advisement.
I'm objecting still because the
you may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
Wow.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir. So let me see it, and I'll take your objection under. I'll take the objection under advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
Go ahead, Attorney
I have
Opper.
all the exhibits.
Go ahead, Attorney Opper. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just creating exhibits now.
Yes. Let me put a little bit of context into this. Is at the beginning of the trial, the state gave a list of the exhibits that they were planning to present. So he thinks that that's the only thing that they were going to use for evidence, but it's not. There's going to be more stuff coming up. Even after you destroyed the door. You went Kool-Aid Man on the door and destroyed it. So they can now get in with that video.
I have all the exhibits, and this was never in it.
Sir, do you recognize what's contained in State's Exhibit 178?
Objection.
Overruled.
Relevancy.
Overruled.
Leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection. Leading.
Overruled. The witness may answer.
I'm still going to object. How is this?
Mr. Brooks, I ask that you honor the ruling that I've been made.
I have all the exhibits, though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made an exhibit?
I'll take
just
this
out
up
of the blue?
outside the presence of the jury, but I'm going to allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence, and the state may continue.
So this exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted. It's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the Ford Escape. This is the video in which that still photo was taken from.
Objection. How does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it
Why?
when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection. Leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll find that it's relevant. I'll receive Exhibit 168. Permission to publish is granted. For the record,
It's 178, Your Honor.
no, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the
Why does he want to do an offer of proof for his appeal if he's not convicted yet? I don't get that part. Like, you need to be convicted for then try to appeal that decision.
jury, but I will allow the state to play it in its entirety without audio.
Your Honor, I have all the exhibits they were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that I didn't
Mr.
even
Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
actually, Your Honor, I changed
He's so mad, and I love it.
my mind. I would like to play the audio, please.
Yes.
This is mind-boggling.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played? Is this setting the foundation?
It's relevant. You questioned the officer about it. You
I
questioned this
question him
detective
about.
about
I
his
question him
knowledge.
about the still frame from the video. The video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
By the way, I never heard this song. I only seen the video here, and they obviously they don't play it with audio. But if I want to do something. If I never had a video get to 400 likes, so if this video gets to 400 likes, I will do a breakdown. I will suffer and listen to this song for you guys, and I'll do a honest review of what I think of it. But vote with your likes if you want to see it. Is it on YouTube? I think it should be. I should be able to get it. And I gotta say, the guy who edited this, who did the edition of this, not bad. Other than Darrell Brooks being there, it's an okay video. I mean, it's
Play the sound. I want to hear it now.
it's not
We'll
bad.
address that later.
We address why it was created out of the blue too.
The transitions are fine, but I haven't like I said, I haven't heard the song. But the only wrong thing about this is that Darrell Brooks is in it. I don't know why they have to flash the gun. Yeah, kudos to the editor of this. That I'm sure is not Darrell Brooks. There's no way he has the know-how to do a transition on Vegas Pro.
Sir, did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, I
A
did.
lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in Exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as State's Exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection. Leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video
There you go.
and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular...
Now, all right, we made it. We made it to this point. This is where I wanted you guys to see yesterday. This is where he just gets mad about it. He can't believe it. He cannot believe that they show his music video.
Particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection. I don't consent to being called that name. And yeah,
Noted.
I
Do you
got
have any questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Objection. That's not a question for the witness, Your Honor.
That
Sustained.
was a question. When was
Sustained.
this
As to the
video
form
made
of
an
the
exhibit?
question,
When was this video made an exhibit? That is a question.
First of all, start with the tapping, my guy. I hate it, and I know you guys hate it. Why does he need to tap the desk? And also, he did the wrong question. He said he didn't understand the objection. She said that this is not a question for the witness, and he understood this is not a question. So I'm gonna miss.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
sustained.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer, Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I-
It would be the same thing. I take that as disrespect because they were allowed to say something, and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please,
and
and
faces.
admonish him?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, I'm good. Can I do my job?
Please.
State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
ever see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to be
I'm with-
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
Yeah.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection.
Maybe he likes it, my guy. Maybe he likes your music. He's a Mad Boy Fly enjoyer.
Argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection. Argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection. That's a
Grounds.
misstatement, Your Honor.
Sustained
it was-
as
it
to
was
the
not
form
brought
of
up
the
in
question
the
assumes
testimony.
facts not in evidence.
If you have seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
He really hates that people are prepared for stuff. Like, he doesn't prepare for nothing, so he expects everyone else to not prepare as well.
I'll stay with my
Hold on.
Objection. Compound. Asked and answered. Misstatement of the facts. Argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection assumes facts, not in evidence.
Sustained. That's to the form of the question.
This is mine.
The only reason why they played the video was because you asked for it. That's the funniest thing. He's like, they plotted this against me, and they may have. I think they may bait him. They may have baited him into asking about the video so they can show it. But that's not facts. That's facts, not in evidence. So we can never know.
Bible. This is my Bible.
What is over there?
Can you clarify again why you viewed the video this morning?
Objection asked and answered.
Sustained.
So you're gonna sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
All right. Thank you.
This is mine, Bible.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason. Because you asked. I see what you people are trying to do. It's not right. It's not fair and it's not right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Opper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr.
by
Brooks, I need to
something that
make
I
a
saw?
record. So just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would-
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr.
That's why I
Brooks, I
raised the
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. You directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to
What do you mean by
that.
it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment?
They just told you that they gave that to you at the beginning. You didn't see it because maybe you didn't look hard enough, or you just dismiss all the video evidence. So, what?
How does it be made an exhibit out of the blue? That was the issue. The issue
State can
didn't
make an
have
offer of
anything to
proof
do
on
with.
that because obviously they marked it as an exhibit.
But
They
with
had
all
it, so
respect,
go
Your
ahead,
Honor, you're
Attorney Opper.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was, how does this, at the last minute, out of the blue, become an exhibit? That was the issue.
Go ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware.
He said social
There's
media.
nothing
he didn't say what it was.
Sir, stop interrupting. We have to make a record of it. You've
Then make the record
interrupted multiple times. I've been abundantly patient
record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at me. Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet, or are you telling me to be quiet?
Telling you.
Go ahead, Attorney Opper.
Thank you, Your Honor.
I'm gonna take that
And
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video, which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you.
All right, I wanted to let I didn't want to interrupt Susan Upper because that was a cathartic moment for her. I think that was one of the one of the moments that she had to be, other than the closing arguments and all of that, but up at this point, this was the only chance that she's had to actually say something back to Darrell, because he's been saying a lot of stuff. He objects to a lot of stuff. But now she had the moment to really let that frustration free. And I love it. Now let's continue.
I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed
He doesn't even care about the trial anymore. He only wants to talk about what Susan just said.
to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
He's so mad that someone talked for a long time. Dude, you spent like an hour saying stuff.
I don't know specifically what you're talking about.
There's a reference made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No. What I've observed is
listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and hee and key. That they've been doing that the whole time. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one.
He's the king of don't assume what I'm thinking, don't assume what I'm going to do, don't assume what I'm saying, and he's just assuming that they're saying stuff about him. Being more of a hypocrite.
One thing you pointed out.
Well, we have cameras. That's what the cameras are for.
Let's refocus our attention on what we're here for, and that's
this trial.
Then
I take that
do you have anything you want to put on the record?
I'm putting it on the record if I get a chance.
No, you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not that she just said. She just made it an exhibit. It was not an exhibit before she made it one.
So do you have some legal basis, sir, for your position? Because I'm not.
What do I need legal basis for when she just admitted on the record that she just made this exhibit up right now?
That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't implying that by saying that she could pull anything out of her suitcase.
So that's a figure of speech.
Okay, so what is it implying to? What would that be implying to?
As attorney,
How would anyone?
all right,
How would
I'm
anyone in
moving
my
on
position?
because you're not providing
How
me
would-
with any
how would
legal
any-
basis.
I didn't even finish.
For me
You told me that I can make the record. I'm attempting to make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I wouldn't get to that if I didn't finish?
You're not.
Because you're speaking nonsense about other stuff that doesn't even matter, my guy. That's why she doesn't think that you're gonna get to it. You're gonna talk for 2 hours about what she just said. And then maybe at the end you're gonna say something about the actual thing that we are here for. But we don't trust you to do that.
Providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you open the door to the playing of that video.
We're not talking about
and the
opening
video
no
was
doors.
previously provided to you during discovery.
We're not talking about opening no doors. We're talking about being fair.
There's absolutely
if I
no
would've did
prejudice
that,
to
Your Honor,
you in
with all
terms
due
of
respect,
surprise.
with
by
all
the
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on.
if
from
I
this
had done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down and
Another word that he doesn't know what it means. It's I need to keep a tally on those words.
I
be
don't know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt.
Mr.
For the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to
That is
come
not,
at me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
things.
that? Are you asking me
I don't
to
need
do
to
that?
ask, I'm telling you.
Yes, yes. This is the Judge Darrell that needs to come out more in this trial. Like, you don't have anything to say to me, sir. I'm telling you, and you have to accept it. And see, right now he shut up. Basically, he shut up. He's like, she was straight with him, and he shut up. What was all the attack before, Brooks? You said or else, or what did you say? You know what that will entail. So what is it entailing, my guy? What are you gonna do about it? I love seeing a bully get shut down. See?
Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing this?
Mr. Brooks, I'm only going to ask you one more time, and if you don't...
It's a yes or no question. That's all you gotta do. You say yes, and then he will be back on the stand, and you can say whatever you want. Just say yes, and that's it.
If I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like,
yes or
I don't
no.
like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks,
appreciate it.
Sit down. I don't care if you don't like my
I'm
tone.
not gonna-
You've
I'm
been
not gonna
pushing
say
my
that.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too.
the utmost of respect
No,
for
you haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's not
Stop
accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm purposely not putting you in the other courtroom
Let's
right
talk to
now.
each other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
See all this gaslighting? See now how he's shifting the blame. Right, like right now, the way that she's talking to him is disrespectful. You're not supposed to talk to me like that. But when he talks to her like whatever he wants, it's fine. But this is what a gaslighter does. She shifted the blame.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the jail?
I'm sorry to cut off the judge, but this is in my mind. This is like an abuser does. Like he is used to submitting women into doing what he wants. Like it doesn't matter what he does wrong. It doesn't matter anything. It just matters how he feels. What they do and what they need to be according to what he's thinking. And I hate that.
The search of your jail cell. Yes or no?
What was the problem with me asking a
All
question
right,
about
he's
the
not
jail
answering
cell?
my question. We'll move on.
I'm trying to understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I
gonna
know?
recess 15 minutes
How do
from
I
now.
know
Take
what
care,
I'm supposed to
everybody.
answer if I don't understand? And I don't agree to a stop.
We're back on the record. State versus Brooks appearances are as they were before.
I don't consent to being called that name for the record.
Still with that, eh?
We would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a
Otherwise-
certified bail form.
No. I'm asking.
Oh.
I'm asking Mr. Brooks.
Oh, sorry.
That was the second of the two bail bonds. Do you have a recollection of whether it was received?
I don't.
Right. Then
I
what was?
know I objected to it.
Are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
We moved, it was either Exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
So maybe just had a misspeak.
Yeah.
You have any recollection of that, sir?
Recollection of what?
He's so defeated right now. He doesn't want anything to do with anything anymore. He's done. He just doesn't care anymore.
What was 178?
178 was the video.
Oh, that was the
video.
most recent one. Okay. What's the request then as it relates to when the jury comes back in?
There was some confusion about Exhibits 175 and 178 that were shown to the jury this morning. Those 175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
All right, sir, do you have any position on how I address this in front of the jury?
Yeah, I'm objected to him being admitted at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but
No,
the
it don't.
fact that I've already ruled on the
Definitely.
admissibility is not something I'm going to revisit.
What I gotta say.
Hold on,
definitely
that door is, all right, it's, sometimes that door upstairs malfunctions, and, all right, I didn't hear the last part of what you said.
What I have to say about anything definitely doesn't matter.
I take huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again?
Because everything that you say that is overruled is not relevant and it's meaningless, so they don't have to address it.
My perspective on all of this, sir, is when you disagree with a ruling, you interrupt, you try to debate the topic again and again, you make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes. I mean, just previous to the break.
I don't know what's on that ceiling. I don't know. Something must be over there because he always looks like that way. I don't know why.
Break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. You chose not to answer my questions, and so I moved on. Now, with respect to, I want to also address exhibits and the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was, frankly, to assist the court and my clerk in keeping track. Most trials, the normal course of action is, as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal, we're not quite there yet, that as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There was nothing improper about what the state did.
You like what he's doing? Like, he's ignoring her. He's reading of the Bible, I guess, and he's totally ignoring what she's saying.
Parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other acts evidence with Erica Patterson. And I frankly kept it out, despite your questions. So, with that, I want to bring the jury back out. There's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
So is that addressing subject matter jurisdiction that you're pulling up?
No.
Here we go. He goes back to the well. He needs to stress subject matter jurisdiction every time.
When would that be proven for the record?
Sir, please don't interrupt me. I need to focus on what I'm doing.
I'm not interrupting you. I'm just asking a question.
All right. I'm not going to be
You're interrupting by
So
asking
would
a
it be
Don't
question.
interrupt me right now. I'm trying to do something on my computer.
Would it be
and I need to
proven on the
focus.
record?
It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed. Not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not.
What's the significance of that?
So that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
What?
That's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then, and we can kind of tidy up the record, and then we'll break for lunch.
Judge, may I remove that exhibit, please?
I think they're right there. So
He's so frustrated that he cannot.
Jury already coming out.
I'll just stick
Okay, so go
All
ahead
right,
and sit it
for the
back
jury.
down. Thank you. Subject matter jurisdiction still hasn't been proven for the record, Your Honor.
No?
Should be proven at some point.
Nope.
Do they have any additional witnesses to call at this time?
No, Your Honor, at this time the state rests.
All right, thank you. All right, then at this time we are going to break for the lunch hour.
All right, the defense is rest. Now we just but we're gonna close the day and we're gonna continue. But they're done. They took them 11 days, 10 and a half days, basically, to present a strong case. One of the best cases that I've seen, like, laid out. It's transparent. The verdict is out. The jury already knows what he's going to do, I'm sure. But let's see how Mr. Darrell goes.
Thank you. Be seated. Mr. Brooks, anything from you at this time, given the state is now rested?
What you mean?
I'm asking you the question. Do you have any requests at this time now that the state has rested?
What request pertaining to what exactly?
To whatever you
I'll ask
want. Any request. Like you say, you want to be more specific. Any request that you have now that they're rested.
Question one more time. Do you have any requests to make at this time now that the state has rested?
I don't understand what you mean by that. That's why I'm trying to get
They
clarification.
say no.
I'm not going to give you legal advice. I'm simply asking the question. Do you have any requests to make at this time now that the state has rested?
I don't know what I'm supposed to say to that. I don't understand what.
You're supposed to say, I request that all the objections be reserved for review. That's what you have to say.
What would that be
I think.
pertaining to?
I can't give you
don't
legal
know.
advice, sir. I'm just asking the question to make a record. I'll ask you one more time. Do you have any requests to make now that the state is rested?
I don't understand.
All right, the other thing I want to do when the jury comes back out is you will recall I read instruction 101 at the very end of the preliminary jury instructions that just has to do with opening statements. I will read that with the caveat. It will just say that the defendant will now make his opening statement. I think it's appropriate given that Mr. Brooks deferred his opening statement until the start of his case. With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to go at 1:30 with your opening statement.
I got a question.
Go ahead.
Do I get to present exhibits and stuff like that too and admit them into evidence?
At what point are we talking about? Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe
Yeah.
the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they documents from the discovery that you have?
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer
Give
for
me an
evidence.
example, please.
I just did. I said I have filings that I want to offer.
She's asking for a specific example. She said, "This paper, look, if this paper that I have right here, I want this to be evidence." And she's gonna say no because that's hearsay and nonsense that you just type up. That's what she wants to hear.
Into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings. Everything
Which
that I filed.
filing, sir?
Every one of them.
Well, they have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm being
filings.
general based on what I've seen thus far. So, are you talking about during your opening statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I filed a number of documents. I think that's on the
Well,
record
without
that I
knowing what
filed.
you're referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure.
Yeah.
That's the best I can tell you at this point.
I don't understand what you mean by that. They will only be relevant to obviously the matter. They would
Sir,
be relevant to anything
I
else.
can't answer that anymore. We're going to take our lunch break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
So I'm not allowed to offer anything in the evidence?
For the record, I never said that. We are.
Yeah, that's good that she said that because he was trying to maneuver the situation for his advantage. All right, that's gonna be it for today. Thank you guys for watching, and please tune back in tomorrow. We're gonna see the opening statement of Mr. Darrell Brooks as he starts his defense. It's gonna be something else. Thank you for watching. Give it a like if you make it this far, and I'll see you guys tomorrow. Have a great day. Bye bye.